And what's it about? So Miranda offered incriminating evidence during a police interrogation without prior notification of his rights under the Fifth Amendment of the United States Constitution. And the Fifth Amendment protects double jeopardy, due process, and against self-incrimination. So double jeopardy is you can't be tried for the same crime twice. Due process is following the process of law, and self-incrimination is like the Miranda rights, is what this court case is about. And so the background is Ernesto Miranda was arrested at his house for kidnapping and raping a 15-year-old girl on March 13th, 1963. And he was interrogated by 2 police officers for 2 hours. And from that interrogation, they got a written confession that was signed by Miranda. But during the interrogation, Miranda wasn't told about his right to counsel, or that he could remain silent, or that his statements could be used in court. So then during his trial, they used his written and signed confession, the prosecutors did. And so Miranda's lawyer, Alvin Moore, he argued that since Miranda didn't know his rights, his confession wasn't voluntary, so it couldn't be used in court. But Moore's objection was overruled, and so Miranda was convicted of rape and kidnapping and sentenced for 20 to 30 years on each charge. And yeah. Okay, then the case went to the Supreme Court of Arizona, where they agreed with using Miranda's confession as evidence. And so then it went on to the Supreme Court. And the Supreme Court decided on June 13th, 1966, in a 5-4 vote, that due to the coercive nature of the interrogation by police, no confession could be admissible under the Fifth Amendment self-incrimination clause, and the Sixth Amendment right to an attorney unless the suspect had been made aware of his rights. And so now the police force was required to inform the arrested persons of their rights under the ruling turned a Miranda warning, which that police officer is holding in that picture. And so the Miranda warning is: you have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to consult an attorney before speaking to the police, and to have an attorney present during questioning. If you cannot afford an attorney, one will be appointed for you. Knowing and understanding your rights, if I explain them to you, are you willing to answer my question without your attorney present? So Miranda was retried after the original case against him was thrown out. And this time the prosecution used witnesses, including his common-law wife, who testified that he told her that he did the crime. So he was convicted in 1967 and sentenced. He was paroled in 72. And after that, he returned to his old neighborhood, and then he was stabbed to death on January 31st, 1976. But the suspect who stabbed him used his right to remain silent, so he was released. So during the Supreme Court trial, another 3 defendants' cases were tied in with Miranda's: an armed robber, a stick-up man, and a bank robber. So they either made plea bargains for lesser charges or were found guilty again, despite the exclusion of their confessions, because their cases were similar to Miranda's in that they also weren't told of their rights. So in Harris versus New York, it stated that the prosecution can still use the defendant's testimony to make the defendant seem like a liar. Like to be like, oh, by the way, the defendant already said they did this crime, but it just will be out there. And so then in Berkmaker versus McCarthy, they decided that in the person subjected to interrogation, they have the benefit of the procedural safeguards in Miranda, regardless of what crime they committed. So the dissenting opinion was Justice Tom Clark, and he argued that the due process clauses of the 5th and 14th Amendments of the Constitution would apply to interrogations, but there's not enough evidence to need a new rule. And so another justice that didn't like this was Byron White, and he argued there's no historical support for the broadening of the 5th Amendment, and that basically they're making a new law with their holding. And many people didn't like the decision in Miranda, and they felt like it would make the police less able to do their job and would lead to an increase in crime. And even Richard Nixon didn't like it, and he spoke out against it. But the ruling held, and today, once an individual chooses to remain silent or asks to see an attorney, the interrogation usually ceases, and then the individual also has the right to stop the interrogation at any time.
All right. Thank you, Megan.